Hello there, my name is Luciano. I am a Brazilian attorney, also licensed in California and Texas. And today we're going to be talking about alternative dispute resolution in Brazil. So ADR means alternative dispute resolution. It means a set of techniques or paths available for those who don't want to engage in a fully fledged lawsuit. So when you have a fully fledged lawsuit, usually we are talking about a process that could take years, and it could be substantially expensive, and it could be also damaging to both parties, not only a defendant who end up losing in court, but sometimes even, like the plaintiff, because for instance, in a lawsuit, it's very common for all the information exchanged in the lawsuit to become public. Now, the main routes for an ADR are going to be mediation, arbitration, or plain negotiation. There is not much to discuss about negotiation. We have discussed about negotiation techniques in some of our other videos, but there is no formal path for negotiation. One of the things we discussed in some of our other videos is that to negotiate after filing a lawsuit in Brazil, it may be a good strategy for some cases. Now, when we're talking about ADR, one of the first things that come to mind is going to be mediation. So we have here a mediation. Mediation is not binding, meaning that, both parties, plaintiff and defendant, they can attend mediation and they engage in a hopefully constructive discussion of each side's pros and cons. And this mediator, which should be a neutral, of course, is not going to be an attorney for either party. It should be like a legal agent. It could be like a former judge. It could be like an attorney who's not working for neither party. This neutral would kind of discuss the case and hopefully, bring a path for both sides to agree to a specific outcome. But again, if one of the parties do not agree with the mediator's recommendation, basically this is non-binding. It's more like an effort for the parties to find an agreed solution before the fully fledged lawsuit. Both in the United States and in Brazil, it may also be part of a specific stage of the lawsuit. So in the United States, after lawsuits filed, it's very common for the judge to ask the parties, are you interested in mediation? And if the parties are, they are going to pay an outside mediator and they are going to attend a session, nowadays mostly through Zoom in the United States. In Brazil, usually Microsoft Meets is more common than Zoom, but in Brazil it does work in the same way. So within the scope of a lawsuit, a judge may also recommend mediation to the parties. And again, this is a non-binding type of, it could be a single meeting, it could be a series of meetings in which both parties are going to try to find common ground and eventually settle before getting too further into the lawsuit. Now, we're going to be talking about arbitration, and arbitration, it's actually binding, meaning that if you enter into an arbitration procedure, whatever decision comes from this arbitration is going to be binding. And interesting enough, like many arbitration procedures, they are going to be done outside of a court. But if you accept to participate in an arbitration and you lose it, then it makes it much easier for the winning party to go back to the court and say, you know what, we won arbitration, and the judge is going to be compelled to enforce the arbitration unless something very wrong in terms of legal procedure happened at the arbitration. Interesting to compare, arbitration is almost like a lawsuit, but outside of the courthouse. So arbitration is like an attempt by private parties to make a lawsuit more efficient, to make it like limited in terms of timeline, and to make it more effective by bringing experts in the disputed type of subject matter to decide on behalf of the agreeing parties. Now, arbitration, for being binding, is not going to show up out of the blue. The parties are going to need to either agree to participate in arbitration, whether within the scope of a lawsuit or most commonly on a contractual basis. Very common for international trade, for international contracts to have an arbitration clause specifying how parties are going to dispute or how parties are going to deal with a dispute outside of courts, meaning that they are obligating themselves to attend an arbitration procedure instead of going straight to the court. So that goes straight to when to opt for ADR, meaning there are points of time in which you can move to ADR. So if you are within the scope of a lawsuit, mediation is probably going to be one of the stages, one of the things that the judge is going to offer eventually to you. Maybe even if you are not in a lawsuit and if you have a dispute, again, with maybe a supplier in Brazil or a client in Brazil, a partner in Brazil, there is nothing precluding you from offering or for recommending mediation, particularly if done in Brazil. So you can pretty much say, listen, we are not seeing eye to eye on this matter, and instead of, like getting to the point of hurting our business relationship, let's go to this mediation, panel, to this mediation chamber, and hopefully we're gonna be able to find a common ground by use of a neutral to review our positions. On the arbitration, like I said, usually it's gonna be a contract clause, the so-called arbitration clause, but again, there is nothing precluding two parties of, instead of engaging in a mediation outside of a lawsuit, to say, you know what, there is this very respected arbitration chamber in our industry. Instead of filing a lawsuit that's going to take years and years and potentially, a lot of money to resolve, let's actually submit ourselves to this arbitration chamber, so the arbitration chamber can decide, and we know that this decision is going to be binding, and it's going to, one way or the other, put an end to our dispute. All right, final topic is going to be tips for success of ADR, of alternative dispute resolution in Brazil. And usually in Brazil, something that is very particular to Brazil, some commerce chambers are going to be chosen as the ideal provider for either mediation or arbitration. One of them is going to be AmCham, or American Chamber, and there is also, which is like Commerce Chamber from Canada. Very interesting enough, like they're pretty famous in Brazil for arbitration, procedures, and mediation. Of course, there are many other players, sometimes not related to other countries' commerce chambers in Brazil, but usually when you're dealing with international business, international trade, it is just natural that those deals or trades or contracts are going to end up finding their way into a commerce chamber dealing with international trade. So we have some tips for those techniques. We usually advise our clients within the scope of trying to negotiate a settlement before you get to the lawsuit stage. But feel free to schedule a consultation so we can review your specific case and advise you accordingly. I hope this content was helpful. Don't forget to download our ebook, The 7 Things You Must Know When Dealing with Disputes in Brazil, and follow us for more tips.